Good morning, everyone. I welcome each one of you to our AOR Aspirants Academy. Today's topic for discussion is Practice and Procedure of the Honorable Supreme Court. That is the first paper for Advocate on Record examination. Before going to the topic, we always have the habit of reciting the prayer, that is the preamble, because we need to remember our forefathers, what was their dream, and whether are we in a position to reach those dreams, how much distance is left out. So we need to see everything. So I will recite the preamble, please repeat it with me, then we will go with the topic. We the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic and republic, and to secure all its citizens justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact and give to ourselves this Constitution. Thank you so much. So let us, with this spirit, Holy Spirit, noble spirit, let us try to achieve the noble ideal of our forefathers. The practice and procedure, that is one of the most important subject for Advocate on Record examination. So to understand the practice and procedure, let us quickly see what is there in, what is the source. The source of AOR examination, where do we derive from the Indian Constitution? That is Article 145 of the Constitution of India. Article 145 of the Constitution of India, rules of court, which deals with rules of court. It says, subject to the provisions of any law made by Parliament, the Supreme Court may time to time, with the approval of the President, make rules for regulating generally the practice and procedure of the court, including rules to the persons practicing before the court, and so on. So the source is 145, which empowered the Honorable Supreme Court to frame rules. So the father and mother for the Supreme Court rules is Article 145. So with this, by virtue of 145, the Supreme Court rules 2013 has been framed by our Honorable Supreme Court. The most important aspect with respect to the eligibility criteria of an AOR is concerned, it is provided under Order 4, Rule 5 of the Supreme Court rules. That is very important. It prescribes that an advocate on record must complete 5 years, that is 4 years that he must be practicing as an advocate, plus 1 year training with an advocate on record who has a standing for almost 10 years. So this was dealt in detail on the last meeting, and that is also uploaded and available in the YouTube. So by virtue of Order 4, Rule 5 of the Supreme Court rules, the Supreme Court has framed the regulations also. Regulation regarding advocate on record examination. Regulations regarding advocates on record examination. This is a part of Supreme Court Rules 2013. It reads like this: in pursuance of the provisions contained in sub-rule 1 of Rule 5 of Order 4, Supreme Court Rules 2013, the following regulations are published for general information. So, under this they have prescribed 4 subjects. Firstly, practice and procedure, the Supreme Court. Subject number 2, drafting. Number 3, advocacy and professional ethics. Number 4, leading cases. So, out of these 4 subjects, today we are going to deal with the first subject, that is practice and procedure of the Supreme Court. So, we are going to deal with a brief idea what is there in the practice and procedure. So, before going to the topic, as a note of caution or as a disclaimer, whatever I say, this is only a guidance. It is up to you to make your own research and then prepare on your own, because disclaimer is always important, because this guidance cannot be the sole criteria for the preparation of an advocate on record examination. For this, there is a world poet called Saint Thiruvalluvar. In his couplet he has said, in Tamil I will say, then I will translate it in English. எப்பொருள் யார் யார் வாய் கேட்பினும் அப்பொருள் மெய்ப்பொருள் காண்பது அறிவு. What does it mean? He says, what is knowledge? What is wisdom? He is asking a question. The wisdom is to ascertain the source, to ascertain the truth from whatever the sources you hear. So, now I am a source of information with respect to advocate on record examination, but the wisdom of the audience, of the listener is, you have to ascertain the truth of whatever the information that you gather from various sources. So, ultimately the accountability rests with the viewers. So, I may be a guiding factor, but you have to proceed further to see what is right and everything. So, with this, let me move on to the practice and procedure subject. Before seeing the subject, I must tell you what are the sources for preparation of this examination. Whatever we do, we need to do a homework. So, before we start the preparation for the subject, we must know what are the materials available for this examination as far as the first paper is concerned. I have noted down nearly 8 sources of information for this subject. The first and foremost is, this is a textbook that I relied upon and I referred. B.R. Agarwala's Supreme Court Practice and Procedure. Authors Raju Ramachandran, Gaurav Agarwal. Publisher is Eastern Book Company. So, this is the book which I have studied. The second source is, now I am moving on to the second source, that is the Supreme Court Practice and Procedure by present Attorney General Mr. R. Venkatramani sir. You can keep one book as a main source, you can keep yet another book as a matter of reference, because you cannot find all the informations in one book. So, main source like main counsel and a proxy counsel. So, this is the second source. Yeah, the Supreme Court Practice and Procedure. Author is Mr. R. Venkatramani, present Attorney General for India. Publisher is Mohan Law House. The third source is any reputed commentaries on the Constitution of India. Yesterday I had an occasion to refer to author V.N. Shukla. I found it very relevant to our AOR examination is concerned. So, I will leave it to you to decide which would be the book. So, this is the third source. The fourth source is Supreme Court Rules 2013. Supreme Court Rules 2013. Fifth source is very important, dear friends. Last 5 years question papers. Last 5 years question papers. You have to get a printout of it and you have to see what are the repeated questions. That is how you will identify what are the important subjects or portions that you will study. Sixth is lecture series conducted by the Honorable Supreme Court Registry. They assign nearly 3 or 2 senior advocates per subject. You all know the subjects are ocean, but they will highlight what are the portions that you need to study. So, you should not miss this lecture series. Number 6. Number 7 is, I have taken a liberty to say, our AOR Aspirants Academy lecture series. We must give credit to ourselves. 7th resource. Please get your chairs. 8th resource, that is also very important, or any other sources as the candidate deemed fit and proper. Like always in the prayer we say, as a last prayer, this honorable court may pass any orders as it deemed fit. So this is also very important. 8th resource is. So now we have got what are the sources by which we can prepare advocate on record examination. So these are the 8 sources. To my best of my ability, I have found this. Now, in this practice and procedure subject, what are the portions, syllabuses that are covered? So this is mainly focused on the jurisdictions of the Honorable Supreme Court and how it is dealt by way of the procedures. If you say Article 32, what is the procedure? How will you file it? That you will find it in Supreme Court rules. So both are this book, that is Supreme Court Practice and Procedure, read with Supreme Court rules, will give a complete picture about the Supreme Court Practice and Procedure. So if we quickly see the index of the Supreme Court Practice and Procedure written by learned senior counsel Mr. Raju Ramachandran and Gaurav Agarwal ji, they deal with first chapter is introduction. They have said how was the evolution of the Honorable Supreme Court, how it was inaugurated, how was their journey. So that is there in the introduction part. Second chapter is, it deals with the writ jurisdiction under Article 32 of the Constitution of India, that falls under extraordinary original jurisdiction. Third chapter is public interest litigation, very very important, because doctrine of locus standi, that was diluted. Even a public spirited person can maintain a petition before the highest court of the land, that is the Honorable Supreme Court, for a poor, underprivileged, ignorant, disabled, a public spirited person can maintain a petition. So that is PIL. And it deals with election of the president and vice president. Chapter 5, which deals with ordinary original jurisdiction, proceedings under Article 131 of the Constitution. It is a suit filed when there is a dispute between two states, or two states on one side and the Union of India on the other side. We will be dealing it in detail in coming sessions. Chapter 7, very very important. Extraordinary appellate jurisdiction, special leave petition under Article 136 of the Constitution. Because we all know majority of the cases are filed by way of special leave petitions. 8th chapter is power of the Supreme Court to review its orders, Article 137 of the Constitution. Once SLP is dismissed, review is filed under Article 137. Chapter 9, advisory jurisdiction of the Supreme Court under Article 143 of the Constitution. President of India can seek advice from the Honorable Supreme Court on matters of public importance. Chapter 10, jurisdiction of the Supreme Court to transfer cases. Jurisdiction of the Supreme Court to transfer cases. If it is a civil case pending in one state, if a petitioner wanted to seek the transfer from one state to another state, for example, Karnataka to Telangana, the jurisdiction lies with the Honorable Supreme Court under section 25 of Civil Procedure Code. If it is a criminal case which you seek a transfer from one state to another state, it is under section 406 of Criminal Procedure Code. Then chapter 11, powers of the Chief Justice of India under section 11 of the Arbitration and Conciliation Act 1996. Chapter 12, contempt jurisdiction of the Supreme Court. Contempt jurisdiction of the Supreme Court. Because when an order is passed by the Honorable Supreme Court under Article 141 of the Constitution, it binds on all the courts within the territory of India. But if there is a disobedience, that too willful disobedience to the court's order, then contempt. Chapter 13, removal and suspension of members of public service commissions. Removal and suspension of members of public service commissions, Article 317. Removal and suspension of members of public service commissions, Article 317. Chapter 14 deals with cost. 15 miscellaneous provisions. Chapter 16 and 17 are most important because it deals with Article 141 of the Constitution, that is binding nature of Supreme Court decisions. Binding nature of Supreme Court decisions under Article 141 of the Constitution. Chapter 17, power of the Supreme Court to do complete justice. The Honorable Supreme Court can pass any orders to do complete justice. It is an inherent power. According to me, this is the only power which makes the Honorable Supreme Court the supreme. You don't find any parallel power either with the Honorable High Court or any other courts. Under Article 142, under the caption complete justice, the Supreme Court is really supreme and can pass any orders. 18, chapter 18 is enforcement of orders of Supreme Court. Enforcement of orders of Supreme Court. Then appendices are given with respect to the Supreme Court rules, everything. Now, having seen almost 18 chapters and other remaining appendices, it is like a ocean, right? But how to deliver it within 3 hours? That is very, very important. Our preparation starts from last 5 years. That is what the rule says. And we have to deliver it within 3 hours. So for which this lecture series conducted by the Honorable Supreme Court Registry, that will help us to focus on what are the main chapters. Secondly, last 5 years questions, because the Supreme Court Registry conducts lecture series only 2 months or 1 month before the examination. Till then we cannot wait. So how to make our preparation? So we have to make our preparation by taking out printout in the last year question papers, last 5 years question papers, and then we have to start marking the questions with the chapters. So if they had asked for 2024, you can mark yes, writ petition has been asked in 2024 with the cross mark. And if it is again asked in the year 2023, you can put again a cross mark. So if you had gone through almost the 5 years question papers and the marking with the chapters, you will understand more number of cross marks will indicate which chapter is most important. So one of my associates, Miss Shivangi Singh, she has assisted me in finding out what are the important chapters. So she has identified for the last 5 years questions, one of the most important chapters is Article 32 of the Constitution of India, because they had asked either by way of detailed question carrying 20 marks also, or 5 marks also, or 10 marks also. So they have not missed any portion given in the writ petition. So this is very important as far as our AOR exam is also concerned, as far as our practice is also concerned. Dear friends, with utmost respect I say this, don't treat this advocate on record examination as a burden, because our mindset has to be changed. Even if there is no AOR examination also, if an advocate wants to practice in the Honorable Supreme Court, he is bound to know all this. But they are making us a compulsive platform to know this, and then one who has come out with flying colors with first mark, second mark, they are encouraging them by awarding gold medal and silver medal, and you are given a designation by saying that you are an advocate on record. You will be the one who will act on behalf of the party, and you will be the one who will plead on behalf of the party before the court. So on the last occasion I said we can have a client counseling, starts with letter C. Thereafter we can draft the petition, AOR can draft the petition, can file the petition, can plead before the court, and then thereafter we can apply for a certified copy of the judgment. A to Z, an advocate on record can do it independently in the Supreme Court. Unlike other advocates or a senior advocate, they require the presence, assistance of advocate on record. An advocate must have an advocate on record to be on Wakalatnama. A senior advocate has to be engaged by advocate on record. That is a privilege given to learned senior advocates. But as far as advocate on record in the Honorable Supreme Court is concerned, he can act independently from client counseling C till the certified copy C. So we can see everything, we can do everything in the Honorable Supreme Court. That is the privilege given to our advocate on record. So considering our responsibility, we must not only see it as a burden, we must see it as a eternal happiness to enhance our knowledge, because knowledge is an ocean, what we have known is only the drop. So with this, let me move on to the most important aspect, that is Article 32 of the Constitution of India. So we have always known that any person can approach the Honorable Supreme Court directly under Article 32. So let us utilize this time by reading all 4 clauses mentioned in Article 32. The difference between a well reputed jurist and normal advocates is we read everything and we do not remember, but jurists, great lawyers, great senior advocates, they see the entire world in a word. So that is how they look at it. So even comma, why there is a comma, why there is a full stop, why there is, instead of using a citizen approaching the court, why do they have used in a different way? So we have to ask ourselves these questions, provided we have a keen interest. So we must enjoy, because once we lift the Constitution of India, definitely lifting the Constitution will lift our life. So always carry this holy book. And Article 32 goes like this: remedies for enforcement of rights conferred by this part. Which part? It falls under part 3 of the Constitution of India. Remedies for enforcement of rights conferred by this part. Clause 1, the right to move. Dear friends, very cautiously every word is coined. They have not said citizen, they have not said person. They start by saying the right to move the Supreme Court. By whom? That is silent. The right to move the Supreme Court by appropriate proceedings. What is appropriate proceedings? We must ask ourselves. For the enforcement of the rights conferred by this part. Which part? Part 3 of the Constitution is guaranteed. So we have asked 3 questions here in the clause 1 itself. The right to move the Supreme Court. So who will move the Supreme Court? Number 1. Number 2, by what mode? They say by appropriate proceedings. So what is appropriate proceedings? Number 2. So these are the 2 questions staring at our face today from clause 1 of Article 32. Now moving on to the next clause 2. The Supreme Court shall have power to issue directions or orders or writs, including writs in the nature of habeas corpus. So we generally taught or understood in law colleges that they have got 5 writs. That's all we know. Yes, 5 writs are there, but apart from that it is including. So therefore that means something extra is there. What is that extra? They shall have powers to issue directions or orders or writs, including writs in the nature of habeas corpus, mandamus, prohibition, quo warranto and certiorari, whichever may be appropriate for the enforcement of any of the rights conferred by this part. So the beautiful aspect here is, the main goal is enforcement of right conferred under this part. The destination of the Honorable Supreme Court, what is their objectives is, I need to enforce the fundamental right guaranteed to the citizens or non-citizens under part 3 of the Constitution. That is the purpose. Whether I do it by writ of habeas corpus, mandamus or any way in the similar nature of directions or orders, the purpose is to enforce the fundamental rights. Clause 3 is quite interesting, dear friends. I want to bring it to your notice. Without prejudice to the powers conferred on the Supreme Court by clauses 1 and 2, Parliament may by law empower any other court. They have not prescribed High Court, because High Court we all know under 226 power is vested. They say any other court, might be district court, this is what my understanding, maybe any other district court, to exercise within the local limits of its jurisdiction all or any of the powers exercisable by the Supreme Court under clause 2. So, whatever the power vested under clause 2, that is writ of habeas corpus and remaining writs, the Supreme Court passes directions or orders for the enforcement, such power can be given to any court to act within that particular jurisdiction by way of law enacted by the Parliament. So, tomorrow the court may say, the Parliament might say, for example, Rohini court might exercise these powers applicable within their jurisdictions for the enforcement. They can do that. This is what my understanding is. Number 4, clause 4 of article 32. The right guaranteed by this article shall not be suspended. They have used the term shall not be suspended except as otherwise provided for by this constitution. So, generally they shall not be suspended. The right guaranteed by this article shall not be suspended except, that means there are exceptions, subject to exceptions, as otherwise provided for by this constitution. So, now we have read all the 4 clauses in article 32. Now, we have got an overall view. The overall view where we are arriving at a conclusion is, the most important aspect is enforcement of fundamental rights guaranteed under part 3 of the constitution. That is most important. Now, to understand the significance of article 32, now moving on to the next heading. Now, we have seen article 32. Significance of article 32. How do you understand its importance? We can understand its importance when we look at the constitutional debates, because that was the origin. Constitutional debates were made in the Constituent Assembly, and every article is well discussed, elaborated, debated, and then it has become a part of the constitution, and it is a rule of law today. So, what did Dr. B.R. Ambedkar had said about this article 32? Very, very important. That got reported in volume 7, Constituent Assembly Debates, volume 7, page number 953. I quote, "If I was asked to name any particular article in this constitution as the most important, an article without which this constitution would be nullity, I could not refer to any other article except this one, that is article 32. It is the very soul of the constitution and the very heart of it." The reason behind saying all this is, we have beautifully drafted and given enormous fundamental rights to the citizens of this country, or non-citizens also, sometimes persons. So, right to life and personal liberty, right to freedom of speech and expression, right to equality, right against untouchability, everything is given. But once it is violated, once those fundamental rights are infringed, when there is no remedy provided, then what is the use? So, therefore, the remedy which is most important, when there is a violation, there should be a remedy, that is remedy to the highest court of the land. So, that is the reason why it is covered under part 3 itself. So, reaching the Honorable Supreme Court, filing a writ petition under article 32 is itself a fundamental right. So, now we have understood the importance of Article 32. It is a remedial nature. Further, to understand its importance, I would like to refer to 7 judges Constitution Bench, L. Chandrakumar versus Union of India. L. Chandrakumar versus Union of India, reported in 1997, volume 3 SEC, page number 261. 1997, volume 3 SEC, page number 261. I am not going into the details of this case, dear friends. What the Honorable Supreme Court has held in this judgment is Article 32 and Article 226 of the Constitution of India is a basic structure of the Constitution. Article 32 is a basic structure of the Constitution. It cannot be taken away by way of law if it is enacted by the Parliament. We all know that in Keshavananda Bharati case, Article 368, which empowered the Parliament to make amendments in the Constitution. But what is the verdict? Majority verdict in Keshavananda Bharati is this: certainly you can make the amendments, Parliament can make the amendments, but without disturbing the basic structure. So, what is the basic structure today? By virtue of L. Chandrakumar case, 32, Article 32 is a basic structure. So, today the Parliament cannot, by passing law, cannot take away the right what is guaranteed under Article 32, because it is a basic structure. See, we must always worship and appreciate the dedication, commitment of the honorable judges, because the Constitution of India is drafted, but whom to entrust that Constitution? Either to the legislative or to the executive, where to entrust? Our forefathers, they believed that we can entrust this Constitution, this holy book which governs the entire nation, only to the Honorable Supreme Court. That is the reason the Honorable Supreme Court is acting as the custodian of the Indian Constitution. It was adopted, Constitution of India adopted on 26th November 1949, but enforced on 26th January 1950. But we are in 2024. From British era, after independence, now we are in digital India. But Constitution remains same with certain amendments, but by the interpretation of the Honorable Supreme Court, even right to privacy, which is not a fundamental right, but read into Article 21, and it becomes a fundamental right, because it was already a natural right. So, we must always, the entire citizens of this country must always indebted to the Honorable Supreme Court. It is a temple of justice and has protected the rights guaranteed under this Constitution. So, the Honorable Supreme Court, how they have beautifully drafted and beautifully delivered a judgment by holding Article 32 is a basic structure of the Constitution. So, from these two, Dr. B.R. Ambedkar's opinion on Article 32 and from L. Chandrakumar case, 7 judges bench, Constitution bench judgment has said Article 32 is a basic structure. So, we could understand how much importance has been assigned to Article 32. Now, I am moving on to the second heading, scope of Article 32. Scope of Article 32. For this, I would like to refer to a case law, very important case law. Romesh Thopper versus State of Madras. Romesh Thopper versus State of Madras, reported in 1950 SCR Supreme Court reports 594, page number 594. I repeat, 1950 SCR, page 594. To understand the scope, why am I referring to this case which got reported in 1950? The reason is the scope of Article 32 was first discussed in this case. You all know 1950 our Constitution of India was born. Immediately thereafter, the Honorable Supreme Court had an opportunity or occasion to discuss about the scope of Article 32. So, in this case, Romesh Thopper, a petitioner, had challenged the order of the state of Madras, by which the magazine of the petitioner was banned for circulation in the state. So, his magazine was banned in circulation within the state of Madras. So, which right is violated? Fundamental right, right to freedom of speech and expression. He had expressed his views through magazine. 1918 is violated. From state of Madras, he has come directly to Delhi by knocking the doors of the Honorable Supreme Court. So, Advocate General for state of Madras had raised a very preliminary objection about the maintainability. What was the objection? The objection is Article 32 is there, fine, but Article 226 is also there, vested with the Honorable High Court. Why he had not approached the Honorable High Court, which is well within the state of Madras? What was the necessity to come to Honorable Supreme Court? So, on the ground of alternative remedy, he wanted a dismissal of the writ petition, because the remedy lies with the Honorable High Court also. Why 32 is to be entertained? That was the preliminary objection, for which, this is very important, for which the Honorable Supreme Court has held. This is at page 596 to 97 of SCR. I just quote, dear friends. The article does not merely confer, they are discussing about Article 32. The article does not merely confer power on this court as Article 226 does on the High Courts. 226 is also there, but this is something different. Article 32 is something different. That is what the Honorable Supreme Court is giving a finding. See, they are enlarging the scope of Article 32 by interpretation. So, the article does not merely confer power on this court as Article 226 does on the High Courts to issue certain writs for the enforcement of the rights conferred by Part 3 or for any purpose as a part of its general jurisdiction. In that case, it would have been more appropriately placed among Articles 131 to 139, which define the jurisdiction. Article 32 provides a guaranteed remedy for the enforcement of those rights, and this remedial right is itself made a fundamental right by being included in Part 3. The Honorable Supreme Court judges are interpreting, it is not like 226 as you think. 226 has got a power to issue writs, no doubt about it. In case our forefathers wanted to keep it as matter of appeal or as a matter of generally like that, filing a writ petition, they should have kept along with 136 only specially petitions which comes under appellate jurisdiction. Why do they want to bring it within the ambit of Part 3, which talks about the fundamental rights? So, once it has been kept under Part 3, that means our forefathers was cautious that this is a fundamental right to approach the Honorable Supreme Court and it cannot be taken away, and it is more highest pedestal, it is kept on a highest pedestal than Article 136, than any other appellate jurisdictions vested with the Honorable Supreme Court, than 226 what is vested with the Honorable High Court. So, this court is thus considered the protector and guarantor of fundamental rights, and it cannot consistently with the responsibility so laid upon it refuse to entertain applications seeking protection against infringement of such rights. So, therefore, we will not just give away our responsibilities from protecting the rights by saying 226 is there, go there. It is their fundamental right. Therefore, we are the protector of the fundamental rights and we cannot shy away from our responsibilities. So, this was the first case discussed in this Ramesh Thapor versus State of Madras. So, how beautifully now we have understood how it is different from other applied jurisdictions, how it is different from Article 226 and how it has been incorporated in Part 3 of the Constitution of India. Dear friends, subject to what you say, 11 o'clock there is a function at Supreme Court and we have got the invitations. So, with this we will conclude for session because people has to reach there also. Therefore, we will conclude for today and we will proceed with the remaining aspects in the next coming session. Thank you so much for your patience, and I am very confident and by seeing the growth of our family, because on the last occasion it was 7, now it has doubled within this very next session. I hope on one day there will be students, candidates here overflowing. Thank you so much for your patience hearing. Thank you. Thank you.
So today that attendance sheet is not.
Yes, sir. Yes, sir. Because I wanted to circulate after the end of our discussion. Sir, you can write your name, mobile number, and email. So therefore, we have a WhatsApp group. We will add you there, and then whatever the sessions that we have, we will circulate it. I welcome each one of our newcomers here, and I do not know how did you come to know. Could you please tell us? Introduce yourself.
My name is Shivani and I've been practicing past
Sit down,
5
please
years,
sit.
sir.
Yeah. Done.
Sir, and I came to know from my senior, Anant, M. Anant Narayan.
MG,
Yes,
yeah,
MG.
okay.
So he messaged me that go and take participate because he will be issuing me the certificate.
Great, great. He's a good friend of mine and my well wisher too. Please have your seat. Ma'am, how did you come to know? Could you please introduce yourself?
Yes, sir. My name is Devi Sharma and I came to know through Patri sir.
Through?
Patri
Oh,
sir.
Patri sir. Great, great. So please spread the word because everybody should get benefited. And because of this, I am also benefited. Reason is, we used to read Article 32 during our college days and during only when we get the cases. Now we have created a compulsive platform for ourselves to spread the light must come within. So we work for 2 days, 3 days, for the last 5 days to work for this 1 hour session, and really it is helpful for myself also, for others also. I would like to quote my Lord Shivraj Patil sir, one of the judges of the Honorable Supreme Court. He said in one of his speeches, when mind is full of knowledge, it is only a storehouse. When that knowledge is shared with others, it becomes a lighthouse. So, and it always multiplies. So, we must be thankful to this time, place. God has provided everything, every opportunity. We will utilize it and we see to that we come first in AOR examination. Thank you so much. Thank you.